On Perspective this week, we're considering your human rights. Should we be concerned about UK politics potentially talking us out of being part of the European Convention on Human Rights? Manx QC Stuart Gale certainly thinks so, but Deputy Chief Minister Jane Poole Wilson, MHK, does not believe this will be a problem. The Minister also talks about her move from MLC to MHK and Minister, considers the ailments of government and how to fix them, as well as explaining the priorities of her Department of Home Affairs. I began by asking Stuart Gale for the Manx Skeet. Who are you and where do you come from?
I was born in Ramsey. Well, no, I wasn't. I was born in Glen Alden, to be exact. Went to the grammar school in Ramsey, left in early 1970s to go to university, went to university in Scotland to study law, and then went to America to study law. Came back to Scotland, qualified as an advocate at the bar in Scotland in 1980, and became a QC in 1993. I've been in practice in Scotland ever since 1980. So however many years that is, 42 years. And about 7 years ago, I came back over to the island and spent some time as a consultant to Keynes. And that's where I sort of became particularly interested in the island's legal system.
And I suppose then from a listener's perspective, for those who don't really understand this and perhaps are confusing the European Union with the European Council, would it be possible? I mean, could you give us a feel for what specifically the convention actually provides?
Yeah, well, the convention sets out a number of principles in articles, and they range from the very basic principle of right to life, right to not be subjected to torture, to have a private life, to have a family life, freedom of association, to be entitled to a fair trial, to be entitled to have access to your property. So there's a whole range of principles that are provided for. And in the event that there is a breach of those principles, then an individual can make a complaint, first of all, to what's called the European Commission on Human Rights. And if that's not successful, then eventually to the European Court of Human Rights. So that's the route that one can follow. Now, in 1998, with the Blair government in the UK, what they did was they decided that instead of the rights under the convention being, I won't say guidance because they weren't guidance, but difficult to enforce, that through the Human Rights Act in the UK, the rights would be part of domestic law. So if you and I have a situation where, for example, we consider that we have not been given a fair trial, we can make a complaint personally about that, and eventually, once one has exhausted the domestic courts, take the matter to the Court of Human Rights in Strasbourg. That's in a nutshell, that's the process that one follows. So, give you an example, it's a very recent one. The Supreme Court in London last week was hearing a case which was a reference from, I think, from the Attorney General of Northern Ireland, about the legality of an act, or I think it must be the regulation, which regulated the I suppose the right of people to protest outside abortion clinics. And obviously, it's a particularly thorny issue in Northern Ireland. And much of the discussion in that case, I watched a little bit of it, because you can watch the Supreme Court on television if you've really got nothing else to do. And I watched a little of it last week, and much of it concerned the various rights to assembly, the rights to protest. So it covers many issues, and that's one of the issues that is currently being considered by the courts in the UK, and presumably it can then, if depending on the decision of the Supreme Court, it can then be taken further to the European Court of Human Rights.
So again, just to avoid any doubt or confusion in the minds of the listener, who will be saying, yes, but we left the European Union. I mean, of course, for the Isle of Man's perspective, we were never in. But they'll be saying, why are these Eurocrats interfering with our affairs? Effectively, we're talking two different systems, really.
They're two entirely different. So an interesting point about that is that I've forgotten how many countries are now in the EU, even after the UK left. It's in the 20s, high 20s, I think. And I think there's 40 countries who are party to the European Convention on Human Rights. And until earlier this year, Russia was a party to the European Convention of Human Rights. Now, since Russia has invaded Ukraine, Russia's been given what we call in Scotland the go mac, which has been kicked out of the European. I'm not sure whether Belarus is also. If it is, it's gone as well. But it's a much wider. So there are countries that are members of the European Convention on Human Rights. I think Turkey, for example, is a member of the European Convention on Human Rights. And of course, Turkey is not a member of the EU. So they're two entirely different things. Well, the convention is, I mean, I look at it from the point of view, both as a lawyer and just as an interested member of the public. I like the idea of having some general principles of what the state and public authorities can do vis-a-vis my clients and vis-a-vis myself. There are so many issues that human rights covers. 10 minutes ago, slightly more than that because we've been talking for 10 minutes, but probably about an hour ago, I was watching the news, and there's one of these awful cases about a boy called Battersby, who is unfortunately, from however it occurred, he's brain dead. And the doctors who are treating him have applied, or the hospital where he's being treated have applied to the court for the life support system that he is on to be withdrawn, and for him to be allowed to die, because he has no prospect of recovery. And he is, according to all the medical evidence that there is, he is brain dead. And his parents opposed that for the High Court in London, and then the judge in the High Court said, "No, I'm sorry, your son is brain dead, and I'm afraid I'm going to allow life support to be withdrawn." They then appealed that to the Court of Appeal, and the Court of Appeal this afternoon said the same thing. And what they are now, there's been a stay of that judgment so that life support isn't immediately withdrawn, to allow the parents to possibly appeal the matter to the European Court of Human Rights.
What this appears to give is an additional right of appeal to what appears to be very sensible principles by which we would all want to live our lives and would want protection to allow us to live our lives in such a way. They might also, though, if they're to parrot the phrases that have been used in relation to the European Union, say, well, surely we want to bring back control and have control of our own laws and our own legislation. So why would we need to have this European body to oversee something which we could administer ourselves?
Well, I think then one needs to go back to where we are at the moment in terms of proposals. Now, the Conservative Party, in its election manifesto of 2019, proposed that the Human Rights Act be repealed, principally because the government looked at it as, I think you've just said, in the same way as interference from Europe on matters that should be within the exclusive domain of the UK. And what the government then proposed was, what it did was in 2020, it established a commission under the chairmanship of Sir Peter Gross, and he investigated, took evidence from many, many people, and he wrote a lengthy report in late last year, 2021, and he issued the report in December last year, and he made certain recommendations about what should happen to the Human Rights Act in the UK, and the government took that on board. And about 2 months ago, Dominic Raab, who is the Deputy Prime Minister and also the Lord Chancellor, issued a consultative document in which he said, strangely, two things. One, which was that the government would remain committed, that was his word, to the European Convention on Human Rights, but that the government would also repeal the Human Rights Act in the UK and establish a Bill of Rights, which would not be European centered. Now, I'm sure the fault is me, but I just don't see how those two propositions are compatible. And I'm slightly encouraged in that by two things I've read and heard recently. One was a question put by Lord Mackay of Clashfern in the House of Lords about 10 days ago. Lord Mackay of Clashfern was formerly Margaret Thatcher's Lord Chancellor in the days when the Lord Chancellor was also a judge. And indeed, Lord Mackay of Clashfern, this was his last question in the House of Lords, because he's now 95 and he's retiring. And indeed, it makes me feel old because I was once James Mackay's junior in a case in 1980. He asked a question of the minister. I don't even know who the minister was in the House of Lords. He effectively put the question in a way that the minister had to say, yes, we will remain part of the European Convention on Human Rights. So that was one thing. The other thing, about 2 days ago in The Guardian, there was an interview with Lady Hale, who was the former president of the Supreme Court in London. And you may remember, she was the judge who announced the decision when, 3 years ago, when the Supreme Court unanimously decided that Boris Johnson, when he sought to prorogue Parliament, acted illegally. So again, a very, very distinguished judge. And she was asked, is it a good idea to get rid of the Human Rights Act and access to the European Court of Human Rights? And she said, no. She said, it's a very sensible act. I can't think why anybody would want to do it. I'm paraphrasing what she said.
I suppose what the British government would say, and it's far from me to speak on their behalf, is they're the elected government, and surely to goodness they shouldn't be being overruled by judges and lawyers in far-flung parts of Europe. In a way, and maybe I'm answering the question for you. That is the whole point of this. Because they are in far-flung parts of Europe, they are in a position to be able to look at this in a more balanced way than perhaps those closer to home.
Well, there's been a great deal of what's called Strasbourg jurisprudence. I mean, there are books and books on this, and the Court of Human Rights in Strasbourg has developed the law as it's gone along, and it's a specialist court which has done that. So, I mean, my concern really is that if the UK does withdraw from the European Convention on Human Rights, then yes, it allows the decision to be taken within the UK and up to the Supreme Court. But that still, I think, takes away the overriding interest that I think people have, which is that one should be able to go to a specialist court which is expert in the particular field of law and which deals with this all the time. The idea of reducing the scope of human rights in the UK is, I think, as ridiculous a decision as withdrawing from the European Union was, which I think was within my lifetime one of the most stupid decisions a British government has ever taken. If they do withdraw from the European Convention on Human Rights, I think the one thing that can be done is that a future government of a different political hue can rejoin. It's much easier to rejoin the European Convention on Human Rights than it is to join the EU.
As far as the Isle of Man is concerned, could the UK leave the convention but the Isle of Man remain as party to it?
I think that would be very difficult, and I think this is the issue for the island. Because the island has its own Human Rights Act, which is effectively a duplicate of the UK Human Rights Act. And if there were to be a situation where somebody on the island wished to take a point of human rights law, eventually they would, if they took it to the European Court of Human Rights, they would have to take it against the UK. Would not be against the island. It would be against the UK, as it was with the Birching case back in '79. It would be very difficult, I think, for the island to remain. I think I probably once said that I used to ask questions for students of constitutional law, and I used to like to think that I knew the answer to them. This is one that I really don't know the answer to, but I think if the UK withdraws from the European Convention, and I think the UK is going to withdraw from the European Convention, then the Isle of Man is going to have to reform its own human rights. It's an act of Tynwald, its own Human Rights Act, so as to somehow reflect what's happened in the UK. It's a unfortunate position to be put in. And in fact, I did notice that in the consultation paper, the government said that it's considering this with all the devolved administrations. So England, so Wales, Scotland, and Northern Ireland. There's not a mention of the Isle of Man, and the Isle of Man is the only one of those devolved administrations that has its own Human Rights Act. So it's a very interesting position for constitutional lawyers far brighter than me. Something is, as they say, afoot in the UK, and it really needs to be examined. If I can just make one other point, there are very few cases on the Isle of Man where human rights law has been considered. There are a couple of recent cases. There was the case of the gentleman who lives up at the top of the Crushers Lane and has effectively made his own little house there. There was an issue as to whether or not there was on land occupied by the department. That case, there was no argument in that case based on Article 8, which is right to family life. And I think it could have been made in that case. Similarly, there was another case, and again, I've forgotten the name of it, where a gentleman complained about the restrictions on coming back to the island during COVID. He was successful, but just based on basic judicial review principles. But he mentioned, unfortunately, again, it was a case that he argued himself without a lawyer. And he argued that, I think in general terms, his human rights had been breached. And it seemed to be that the idea was what's called an Article 1, Protocol 1 argument, which is wasn't able to make use of his property. That was never going to succeed. But what might have succeeded was an Article 8. So that could have been a possible. So human rights is there for to be used on the Isle of Man, and I think if it was just simply withdrawn, it would be a very great shame. I think the scope of human rights, as contained in the European Convention on Human Rights, is much wider than what is being proposed by the Bill of Rights that I've seen. I still find it offensive that the government is effectively using what's quite clearly a prejudice against judgments being taken elsewhere. And I see no reason why there shouldn't be. These judgments continue to be made in the European Court.
I asked the Minister what the impact of the UK's potential withdrawal from the Convention would have on our human rights.
So I think first of all, it's probably worth, Phil, being clear that as we understand it at the moment on the island, it's not actually the UK government's policy to exit the European Convention on Human Rights. As we understand it, what is proposed through their Bill of Rights is to actually reenact in the UK how the European Convention rights are put into their domestic law. So, like us, they currently have a Human Rights Act. It predates ours. I think theirs is 1998. And what they're proposing to do, we understand, is not exit the European Convention itself, but repeal their own Human Rights Act and replace it with their proposed Bill of Rights bill. So the way in which they put those convention rights into their domestic law is proposed to change.
And this matters to us because UK's membership of the European Convention on Human Rights kind of is the way in for the Isle of Man. I mean, potentially we could have membership in our own right, but it would be unusual were that the case. Well,
you're right that because of our status as a Crown dependency, the way the Isle of Man signs up to a convention like the European Convention on Human Rights is through the UK, for want of a better expression. There is, as I understand it, I don't have details of the examples of this, but as I understand it, there is precedent for when the UK has exited or denounced, is the official language, a convention that the Isle of Man has been able to stay in. But as I say, that is not in our understanding, and we are, you will understand, monitoring the situation closely, and we will monitor the progress of the Bill of Rights bill through the UK Parliament as well. But as we understand it, the proposal is not to exit the convention. It is for the UK to change how those rights are put in place in domestic law. What it means for the Isle of Man is we have our own Human Rights Act 2001. Now, the choice of the Parliament in England and Wales to change their domestic legal provision does not affect us. So we are free to determine not to change, to keep our own Human Rights Act as it is. And so that, I think, is where the distinction comes in.
So effectively, our 2001 Act is fine unless there is a significant change in terms of the UK's position with regards to the convention.
I think, yes, the thing that would be of most significance, I suppose, for us is if the government in the UK changed policy and sought to withdraw from the European Convention itself. That would pose a question for us. And for that reason, obviously, we will closely monitor what happens in the UK. I think the other thing, and this is, of course, all subject to what the UK's Bill of Rights bill ends up looking like, should it go through. One of the things that's proposed currently, I understand, is to make the Supreme Court in England and Wales the ultimate court of determination on human rights matters. Now, as things stand, it's the European Court in Strasbourg, which is the ultimate court of appeal on these matters. So for as long, again, as I understand it, for as long as we are signed up to the convention, I would understand that the Isle of Man's ultimate final court of appeal would be still the European Court in Strasbourg. But those are the points of detail that I think it's important for us to monitor as the UK progresses its own legislation, and for us to understand fully any implications and make sure that we consider how we address those as they arise.
And of course, this matters to all citizens in the Isle of Man. Well, perhaps you could tell me why Isle of Man government thinks membership of the convention is important.
Well, I think, it is recognised that these human rights are designed to underpin our whole legislative philosophy. If anybody picks up a piece of legislation or a bill as it joins the branches of Tynwald, they will see that invariably there's a statement in the bill that the mover of the bill is satisfied that it complies with human rights. And they are underpinning principles. Some of them are absolute rights, some of them are balanced rights, where it's recognised there's a balance to be struck between, and the right to privacy is a good one, the right to privacy in a family life. There's always a balance to be struck between the individual's right and sometimes the state's right, depending on particular circumstances. But the point being that these are fundamental rights that we ought to take account of in how we legislate and then how we enforce legislation in practice.
And if, for example, the Bill of Rights that the UK government is proposing to introduce, when that becomes more evident in terms of its scope and structure, it looks attractive. Is there any chance that the Isle of Man might mirror something like that? I
think, obviously everybody has a different view on what the particular provisions are trying to achieve. And I suppose that would be the question always. I mean, what is it that is sought to be achieved? Does the Parliament in the UK have some different considerations to the considerations we would have in the Isle of Man? Does it mean that they have a different basis for trying to do things differently? I mean, those are questions that I would say the Parliament in Westminster have to grapple with and work out. I think from our perspective, we are in that fortunate position of being able to legislate for ourselves. And I suppose the question we must ask ourselves is, are we satisfied that our Human Rights Act is fit for purpose and does what we need it to do? If things change, of course, it would be a foolish government or parliament that was never open to looking at things and looking at why you would adapt something. But you would need a reason, would be my view. And we should look at that from our Isle of Man perspective.
In effect, then, the Isle of Man government's position appears to be, if it ain't broke, don't fix it.
I think that's a fair summary, actually, Phil. I think, we have a lot of legislation planned for this administration. I think we have to be mindful of what we should be prioritising in terms of our legislative programme ourselves. And yes, if there isn't a reason to change something like our Human Rights Act, then we have got plenty of things that we can be working on in terms of our legislative programme.
Which seems like an entirely appropriate point in the interview to move on to your role in the Department of Home Affairs. Obviously, you spent some time, was it 2-3 years as MLC?
It was 4.
4 years, okay.
Just over 4.
Great. And now, not quite a year as an MHK, I suppose to start with. Is there any difference between being an MHK and an MLC?
Yes, there is. I as anyone, as you will know, but anyone who's ever been involved in Tynwald or who follows Tynwald closely will know there is a ton of work. If you're going to get stuck in, there's plenty to do. So, my experience as a member of Legislative Council was a huge variety of roles and work. Personally, very, very focused on the legislative side there. What I would say is different with my experience of being an MHK so far is, one, becoming a minister and the department responsibilities and workload. Allied to that is obviously the Council of Ministers' responsibilities and workload. And I think the other thing that's significant and different for me is the constituency workload. I mean, I yes, I had individuals contacting me before when I was a member of Legislative Council to do with specific matters they knew I was interested in or involved in. But I think that day-to-day general contact from constituents with a whole range of matters and queries, that's an increase in volume.
And has that surprised you?
I don't think I've had time to be surprised, if that's true, if that's a fair comment. I think the truth is, post the election, everything happens with a degree of impetus and speed, and you just get on with it. It's interesting you ask me about whether I'm surprised. I think I've adjusted and recognised what's different, but you just get on with it as well.
So not only becoming an MHK, but also becoming a minister, and both these new roles that you've taken on have extra work associated with them. So are you a lot busier, would you say, than you were as an MLC?
I'm not sure I would say a lot busier. I'm definitely busier in different directions, and for sure you have to juggle lots of different things. I think the other change for me is probably more outside commitments, if I can put it that way. So more evening and weekend events, whether they're constituency or attached to responsibilities. But the reading workload, I mean, I was always a keen person to try and read what we were doing, whether it was legislation or policy work in any event. Now it happens in a different way, in that I see it through Council of Ministers. So the processing of it happens in a slightly different way, I would say. But it's demanding for sure, but it's endlessly interesting and I would say invigorating. I mean, challenging, definitely, but endlessly invigorating and interesting and worthwhile.
And that, of course, is certainly for me anyway, was one of the things I found most difficult to come to terms with. In essence, the discussions that happened in Tynwald happened a month before in the Council of Ministers, when you were considering business to go on the agenda. And let's face it, 90% of the business on Tynwald's agenda is Council of Ministers business. So it often felt quite difficult to get motivated to make the public speeches in Tynwald because you'd already had the discussion and the debate in Council of Ministers.
And I think, the public debate is so important. I think the other interesting thing, though, is that balance between, are you adding something to that debate, or are you just reiterating points already made by fellow members? And sometimes there's value, I think, in reiterating points, but I think there's an importance in capturing diversity of view in the public domain. So yes, I mean, you wouldn't expect, for very good reason, that every member of Council of Ministers hops up on every item, because particularly where there may be a clear view from the contributions that come forward that people are content, that they think it is the right direction, they're content with the content of regulations or whatever it may be. So I think, when it comes to actually the Tynwald sittings themselves, if it's a department matter or law that's being moved, then obviously that's my responsibility to be able to move that well, and critically be able to engage with people in the debate and answer their questions.
And in relation to Home Affairs, it's a reasonably open secret that the chief executive there, Dan Davis, was sent in to close the department down, and yet it appears that the Department of Home Affairs lives to fight again. There's no intention of getting rid of that department now. I
looked at the position when I first became minister, and I think the thinking was what is there any way that the work that Home Affairs done could be done differently? And I think the fact is that most of what I think the public see of Home Affairs anyway are its operational divisions. So they see the constabulary, they see the fire and rescue service. What they probably see less of actually is the service around prison and probation, the emergency services joint control room, and the civil defence and emergency planning services. But actually the bulk of the staff and a lot of what Home Affairs is responsible for are those frontline operational areas. So actually in restructuring the department, you have to ask yourself what would be the benefit compared to the amount of time and work that would be involved in that restructure. And you will know, Phil, the glorious item that we have, the transfer of functions order, when we look to move different functions around parts of government. And a lot of work goes into those things because you cannot drop the ball. If you're moving functions, you've got to make sure they go somewhere and there's a reason for them going there. And I think other factors which are really critical with Home Affairs is there's a reason why the Constabulary and the Chief Constable are operationally independent of politicians. One of the thoughts was, could some of Home Affairs functions in the centre move to somewhere like Cabinet Office? But actually then what you do is make a link closer in between the Constabulary and the Chief Constable and the centre of government. So I think I came to the view that whilst there are of course things you can do, the work and time involved to implement some of that was not necessarily going to generate the benefit that I think would justify that. And actually, we have a huge amount of legislation and policy work to get on with. And my honest view is I would much prefer officers to focus on delivery of what we've already got and what we need to try and do, rather than moving things around for what I'm not convinced would have been a whole amount of efficiency and benefit.
And yet the Chief Minister, when he spoke to Agenda a few weeks ago, was very clear that we don't need more civil servants to deliver the bold economic strategy, that this is all going to happen through the private sector effectively taking the load. But you need to enable the private sector to do that, and you need officers in place to carry out the policies that are going to be required, the legislative changes that are going to be required to actually deliver this. Do you think perhaps some of the sound bites that occur in relation to the size of government are misguided?
I think two things. I think first of all, it is important that government is efficient, and a lot of that I think is to do with clear focus on what we should be doing and prioritising. Because I think where we can go wrong is when we suddenly say to the officers we have got, well, we want to do 10 things all at the same time, and that's pretty impossible. So then we dilute what they're doing, and we're in danger of not delivering anything or not delivering it as well as we should. So I think that's a responsibility, is to have clear prioritisation and effective use of resource. I think the other thing is that when we talk about the public service in the Isle of Man, the bulk of our staff are in these frontline roles. They are the constabulary. You look at the staffing profile of Home Affairs, for example. We have in the region of 12 people sitting in the centre who are responsible for statutory functions that we hold as a department, as well as policy and delivering major legislation. And I will remind people what that is. It's domestic abuse, sexual offences, justice reform. And in the next legislative programme, we're looking at things like sentencing, like modernisation of our firearms laws, fire safety and so on. These are important pieces of legislation. So we've got these people sitting in the centre doing all of that, as well as supporting all the parliamentary work and questions and so on. But far and away, the bulk of our staff are the constabulary. The people who are delivering the frontline service, the fire and rescue service, the emergency services joint control room on call 24/7. We have one paid emergency planning officer, Jane Kelly, who does sterling work, and we have about 47 civil defence volunteers. And we have a prison and probation service, and again, they are responsible for operating our prison 24/7, and a probation service to actually support not only rehabilitation from people who've served sentences, but also to try and support people in terms of community sentences and so on. And so that's far and away the bulk of our staffing. And as you go around the different aspects of the public service, you look at Manx Care, you look at education and so on, you do see a lot of frontline staff. So I think it's important to be clear that there are a lot of people doing delivery of the services people expect and want. But also, yes, there are people sitting in departments who are there looking at policy, legislation, and where there are statutory functions as well that have to be complied with. They're doing that work too.
I'm going to use an elaborate analogy here, so forgive me and bear with, as they say. Part of the problem I certainly detected, and I think many people detect, is it's not so much the staff and their ability, it's the process that they have to follow. And to a certain extent, the Chief Minister touched on this when he was describing the lazy processes of government. It does often feel as though if you're using the analogy of a hammer and a nail, trying to hammer the nail into the piece of wood, the nail is wrapped up in wool and cloth and bubble wrap, as is the hammer. And it's an incredibly difficult job to actually hammer the nail in because of that. Government wraps itself up in so much red tape, so many processes. Is it time that we began, or government began, to streamline these things?
Yes, I mean, it was my observation early on, because my background has always been working in the private sector by and large. And it was my observation that, yes, there were so many layers to move through to get something done that it was challenging. And it can feel very frustrating if you want to get on with things and you want to actually implement change. And I think what is important, though, is proper governance. So I think the real art of it is to have appropriate and proportionate and effective governance. I don't think that necessarily means layer upon layer upon layer, because there's a slight danger then that people generate papers to tick the box of each layer. I think it is about the challenge and engagement of officers and politicians as they go along to make sure that there is proper governance. Because, no one would thank anybody if questions weren't asked and business cases or policy ideas weren't probed as they were in development or coming forward. That is really important, to try and make sure that what you do deliver is fit for purpose. But it's not to say you need layer upon layer to achieve that if you can be effective in your governance and scrutiny arrangements.
To a certain extent, we've believed our own propaganda, haven't we, as government? Well, I say we, you. The Isle of Man government believes its own propaganda, which is we are small, we can get decisions made quickly, we can move quickly on things. This is the message that has been sold to the private sector, but I think many people, probably most people in the private sector, would say it's far from the truth. How do you actually change the system? How do you move it from where it is, which is still quite clunky and not functioning in the efficient way that we've been talking, to that position? It's quite a big ask, isn't it? And
I think you raised something that struck me from the KPMG research work, was a sort of interesting two sides of the same coin, because in all the survey and research work they did, one of our strengths that came out was we've got a track record of developing new sectors quite effectively, actually. And then on the other side of it, one of our challenges is, well, is there too much red tape and do things take too long? And they are two sides of the same coin. So I suppose, the things that I see working well, and I'm really keen to do this from a Home Affairs perspective, but I think it also works in terms of future development of our economy and our mission to make sure we're sustainable and so on, and tackle things like energy decarbonisation, is getting the right people in the room quite quickly and getting some clarity. Because I think where things are complex or touch more than one department, or indeed should have buy-in from relevant private sector expertise and so on, I think it's important to get those people involved, get the right people involved very early on. So I can think of examples. We've got banking resolution legislation on the books now. I know that all the background work was done with people who were experts and who knew how those systems of legislation operated elsewhere. So we were very effective. We got the right expertise in quite early on. And then it means that you can bring forward legislation in a sensible way that's fit for purpose and people have confidence in. I think about, if I think about from a Home Affairs perspective, there are lots of things where, if we're talking about early intervention and prevention, we as a department have to work very closely with health and social care, because a lot of what works in practice is around our social care provision and interventions that are provided there. So it won't work unless we work collaboratively. And, what we think is there's probably a lot of good work going on, but perhaps it isn't as joined up as it might be, or perhaps it isn't sort of overseen as much as it might be to see what works and what doesn't, and then that agility to actually adapt and change and develop. So I think we do some things really, really well. And it's about taking what's good and effective at the moment and spreading it across the piece, I think. And particularly if we're going to deliver our ambitions around the economy and the vision for the island, yes, effectiveness, getting the right people in the room, and understanding what the policy is, what the objectives are, and the roadmap to delivering it, absolutely critical.
I sort of... how would you put it, brought you here under false pretenses because we're going to talk a lot more about Home Affairs. We're about to, we've got 2 or 3 minutes left. So here's your chance. What are the big issues that you hope to tackle in the, I suppose, by this time next year, what would you hope to have achieved? And by the end of your term, assuming that you stay in Home Affairs for the next 4 years? So
things that, I would encourage your listeners to look at our delivery plan because that will tell you a whole range of things that we're working on. But some big things that when I was chair of the Constitutional, Legal Affairs and Justice Committee were brought to Tynwald that are now in train are our review into legal services. So I hope that the report on that by Lord Garnier will be produced by the end of 2022 and we'll be able to bring something forward to Tynwald then in 2023. Also the review by Stephen Wooler into the Attorney General's role, that's underway as well. I made a statement in Tynwald last week about launching a review into drugs and the harms they cause, illicit substances. So that's due to deliver later in 2023, but again, with a view to informing policy and so on. Then in terms of our operational work, we've got an inspection report we're due to receive, I hope imminently, into the constabulary, which looks at areas of, specifically we asked for them to look at areas of governance, at public protection in terms of particularly the vulnerable, and also at capacity and effectiveness in the area of serious and organised crime. So depending on what comes out of that review, I will be looking to see what we need to do to address those things. We also want to put in place reviews. We will have to do a review with the National Fire Chiefs Council, actually, due to technical issues with trying to get Her Majesty's Inspectorate over, but to look at the Fire and Rescue Service and a community risk management plan to plan for the future of the Fire and Rescue Service and its effectiveness. And we'll also put in place a review of the Prison and Probation Service, which is also doing excellent work, a lot of work around rehabilitation. We've got a workshop that's now been built on the prison, designed to help reskill and increase people's opportunity to get work when they leave the prison. A lot of work also in our community services, and a lot of work in the constabulary around reducing harm and particularly looking after some of our vulnerable people and our young people in terms of diverting them. So there is a huge amount going on. And I should also say I really want to, by this time next year, have seen our domestic abuse legislation not only implemented but up and running, our sexual offences legislation and our justice reform, and to have some good policy work underway around the other areas of legislation that we've got listed in our programme. Lots.
Well, Deputy Chief Minister and Minister for Home Affairs, you've obviously got a lot on your plate, so thank you very much for sparing some time to come up and talk to us, and hopefully we'll have you back on soon to talk a lot more about the work that your department's doing.
Thank you very much, Phil.
Should we be concerned about a potential loss of our human rights? Would the UK's proposed Bill of Human Rights be sufficient? Does this current government have the ability to change the culture and processes of government where so many in the past have tried and failed? The Minister certainly appears to understand the problems and has identified the way forward. She is part of a council of ministers that appears to have gelled around a collective vision of what needs to change and why. But can they deliver? Is Stuart Gale's concern justified, or is he worrying us all unnecessarily? Please get in touch with Phil Gorn at manxradio.com and let me know your thoughts and views on the programme. And don't forget, the podcast is available from Manx Radio's website. But for now, I'm Phil Gorn, Goramayus and Gaitach Rum. Thanks for listening.